One public servant is culled out after 20 years, needs to be given sanction prima facie because of ABC. He doesn't say it. Now, there's no reasoning about why he's guilty prima facie or why the cabinet is wrong. See, now after the case is started, we will not file an affidavit. We will produce files. None of the reasoning in the files by the lower officers, not one word is reflected in the impugned order. It is always sitting at a 10-mile distance from all these decisions over 20 years. But in fact, it's a very unusual case. I mean, I'm going to be developing all this. It's a very, very interesting case, fellows. 23 years. More than 23 years, at least 23 public servants must have been involved in this. The list of dates the Lordship has got from my side and this side.
Yes.
One person is singled out by these complainants, 3 complainants, with somewhat dubious antecedents sketched in my petition. One public servant is culled out after 20 years. And in those 20 years, this man has been a minister from his 1984, I think he became a minister in the 80s. Across, he's held many portfolios. No particular portfolio on this issue, no particular file, no particular decision, no particular recommendation, no particular approval. Your Lordship will not easily find a case like that. Your Lordship finds. Now, I can understand the governor saying, despite this, I find Mr. Singhvi's reasoning wrong by 1, 2, 3. But more importantly, apart from Mr. Singhvi's reasoning being wrong, I find that Mr. Siddaramaiah is complicit or is involved prima facie or needs to be given sanction prima facie because of ABC. He doesn't say it. He doesn't say it. He doesn't address the issue. Which brings me to the next point. And therefore, very important clarification. I'm very genuinely grateful for your Lordship's query. 2 answers to that. 1, your Lordship is not carving out a new category of presumptive bias. 2, MP, which is the only case relied upon for only by the other side, forget the other side, by the governor, is a case where they did not take up apparent bias in a cabinet governor case. And 3, it must show, therefore, a perverse 2 plus 2 is equal to 5 error amounting to manifest irrationality, which the governor has not said. He's not even said so. If he had said so, I would have shown he's wrong. But I don't need to show that because he has not said so. Now, which is why it brings me to my 3rd point. It is because of the previous point that my learned friends do something very extraordinary. That is, the state government. I'm sorry, the person representing the governor, not the state government, the person representing the governor. Of course, governor acts to the state government, but he is represented by a separate council. Very extraordinary thing. Keeping in view that there is nothing about manifest irrationality. There is nothing about any reason by the governor and nothing reflecting the process of ratiocination. I'll just put it very nicely in many judgments. These are the materials. That is the conclusion. The chain which links the material with the conclusion is known as the process of ratiocination, the process of reasoning. Now, there is no reasoning about why he is guilty, prima facie, or why the cabinet is wrong. The only reasoning is that the presumptive doctrine my Lord put. Per se the cabinet, per se the chief minister, therefore I must act. Why I must act is not there. Which is why a 3rd point is pressed into service after the case starts. What is that 3rd point? Knowing that there is no manifest irrationality commented by the governor, knowing that he has not dealt with any issue about Mr. Siddaramaiah, knowing that he has not found any reason to deal with the cabinet itself. They say now, after the case is started, we will not file an affidavit. We will produce files. And I mean that, like Alice, it gets more and more curious. So first thing is, I will produce files. Files are produced. Second thing is, in the files, there is only, if you also look carefully, a chart saying 2 versions. Version 1, version 2. There will always be 2 versions, There is hardly a case which does not have 2 versions. Life is all about grey, very rarely black and white.
2 versions.
And in the entire bunch, big fat bunch given to your Lordships, he doesn't say anything except at the end, I think it should be given. But more importantly, none of the reasoning in the files by the lower officers, not one word is reflected in the impugned order. There is no law that I know of that you produce material and say you deem this sanction order to be valid, because at the back of my office, people gave me 5, 10, 12 versions with 1,000 pages of files. That is like saying that I will be the inscrutable sphinx. Behind the inscrutable sphinx, the pharaohs put a lot of gold and a lot of saman inside.
The silence comes about.
So I will remain the sphinx, but the saman behind in my grave can speak for Malus. It all lying in the.
No, that's right. Inscrutable face of the sphinx has something behind it which cannot be projected by that silence.
And your lordship as a judge should be deemed to validate the inscrutable face because of the saman behind it. But Malus, interestingly, that huge treasure house of saman is not finding a word of reflection in the order. Well, I can understand. Nobody is saying that the governor is a judge who's writing a 50-page judgment. Nobody is suggesting that. The governor could have given some reasoning culled out from those 2 versions and 1,000 pages. It is not for your lordships to rewrite the order of the governor. That I am the judge, you have thrown at me 1,000 pages, the order says nothing. I as the judge will ex post facto validate it by giving these reasons. Which ultimately comes back to the same point, Malis. The point remains the same. That your lordships is entitled to quash this order on the short ground that it is not dealing with these issues. Neither manifest irrationality nor why. You are saying, of course, that there are reasons inside. But Malis, and 2 versions is not a sufficient ground at all. Much more so, Malis, when you are disagreeing. You are disagreeing.
Yes.
You are not upholding. Your lordship knows, Malis. There's a difference. Your lordship judicial review is much more heightened when the primary matter is coming on a disagreement. Your judicial review is a little different when it's coming on an affirmation. So that was the 3rd and 4th point, Malis, which I'll be developing. The other point is, Malis, about 17A. Now, Malis, there are 2 facets there I wanted to just touch on, then I'll be developing them later. Well, it's 17A is not, Malis, in any manner 2 or 3 points. First, in 17A, the interpretation canvas for your lordship is to an extent, Malis, faulty and erroneous, is my submission by the other side. Why is that? A very broad brush blanket proposition is thrown at your lordships. Lalita Kumari test is 17A. I strongly object to that. Lalita Kumari test is not 17A test. In fact, it's very interesting. I've now investigated the legislative history of 17A. The idea of 17A was to provide a genuine, strong filter.
Yes, a protective layer.
Protective layer is the correct word, filter is the correct word, and umbrella of protection is the correct word.
No, both are used. To protective layer to protect the innocent and not shield
Not
the guilty.
shield the guilty. Correct.
That is what is
correct. Absolutely. But Balaz, Lalita Kumari, born much later, can't be just read into 17A.
No,
His
when
tests are all mixed up.
17A comes into the statute,
Yes.
Lalita Kumari is 4 years before the 17A coming into the statute.
No, that's true, Malas. But the FIR test of Lalita Kumari could have easily been put in 17A.
Oh, that is not put anyway.
No, not only that. I show that. But in fact, the legislative history originally of 17A provided for the filter through the LawChakra. That's very interesting. The idea was that I am now not on the deletion because the first argument will be deleted, which means the filter is on. That's not the argument. But what happened was that they went through very draft. I've got in my note. Broadly, it said it is a protected. They were emphasizing the protection. Otherwise, governance will come to a standstill. That's the whole idea of this. We have enough people taking pot shots every time. And according to me, this is a classic case because after 20 years, your lordship has different kinds of. But the protective layer originally envisaged was A, a full substantive, and B, it had to go to a very detailed scrutiny, and they put the LawChakra. Then they said LawChakra will be a different institution. So we change it only as to the hooper, not the test. We change it to the government or the police officer. So the change is from him to me. The change is not of the degree or the heightened degree of scrutiny required. That's going to be my point. Then, to dissolve it from that higher test into a Lalita Kumari test. Lalita Kumari test is a very, Lordship know what Lalita Kumari test is, but at the end of the day, it is ultimately, well, you go and file something and you're supposed to act on that. That is, well, reducing the entire object of 17A.